Good morning. I'm Stephen Colby, and welcome to How to Protect Your Intellectual Property, sponsored by IDEA to IPO. I want to thank Rob and his crew for helping put this seminar together. As always, they do a great job. So I'm Stephen Colby. I am a patent attorney. I am a partner at Ramon Law, which is a semi-virtual law firm with about 45 offices around the world. I'm going to be talking today about basic ideas about how to protect your intellectual property. And this seminar is going to be directed at early stage companies. In other words, people who are just starting out and want to make sure that the IP, the intellectual property that they have, is at least protected, so they know what they're doing. This can be a really important aspect of your business, as we shall see. Most of my clients are Silicon Valley type early stage startups. They're of course not all based in Silicon Valley. They're based in Europe and Asia and Australia and Silicon Valley. But the ideas I'm going to present today are kind of directed at that type of company, at a company that is expecting to take funding and grow really quickly and hopefully have a nice exit for the founders someday. One more disclaimer here. Listening to this seminar doesn't establish a client relationship, attorney relationship between us. That requires some actual paperwork and an agreement and so on. And finally, I am a California attorney and a US patent attorney. So the law that I'm going to be talking about today, where I am talking about law, is US law only. I'm not a European patent attorney or a Chinese patent attorney, etc. Right? Okay, folks, so let's get on with it. All right. Now, one more thing. If you have any questions, I will answer them at the end. And please put them in the Q&A tab, in the questions and answers tab, so that way you guys can chat in the chat tab. And then at the end, I'll probably talk for about an hour. And at the end, I will go through the Q&A first. And then if I have time, I'll maybe look a little bit at the chat, but feel free to send your questions to Q&A tab. Great. Thanks a lot. All right, let's go. Pardon me. Find my cursor. Yay. Second slide. Yeah. Okay, why would you do this? Right? You're a cash-starved startup, right? You're worried about buying peanut butter and Wonder Bread or filing patent applications. Which are you going to do, right? Well, there's a reason for this, okay? People ask me, why should a company that's just starting out put thousands of dollars into developing an IP portfolio, okay? So the reason is valuation, okay? You want your company to be valued more. Now that's not, a lot of times I see people give the wrong answer. I'll see somebody at a pitch event and an investor will ask them about the competition, and the founder will say, oh, we don't have to worry about the competition. We have a provisional patent application, right? Well, that's not the right answer, because the provisional patent application is something that could be a patent in 3 to 5 years, right? And then to enforce would cost millions of dollars. So no, that's not the reason you do patents, right? That's the wrong answer to the competitive question, right? There's other things about your company that are going to give you a big advantage over the competitor, right? Those are the things you're going to talk about to the investor. But for a startup, my goal is to put together IP, whether it's patents or trademarks or trade secrets or whatever, that makes your company more valuable. And if I do my job right, every time you raise a round of money, okay, you trade equity for cash, you get a better price for it. And I pay for it myself many times over. And then at the end, at the exit, right? When somebody is coming along and saying, should we buy this little company for $100 million or $20 million, whatever, right? Or should we just redo it all ourselves with our 200 engineers in a matter of months, right? Well, the IP can make a big difference there in their spreadsheet, in their calculations of what they're willing to pay for you. Right? The IP in the hands of your acquirer can be a big powerful leverage because they'll have the money to use it against competitors and fight for it and do the proper things, right? So keep in mind, everything you do with intellectual property is to increase the valuation of your company, right? Okay, so what kind of IP can you get? Well, the most common things are copyright, trademark, trade secrets, and patents. Not necessarily in that order, but pretty much everybody's going to have some material that's copyrightable, right? That could be a white paper, some marketing material, your website, graphics in your, even if you have a company that is selling clothing on Amazon, you have models with your product, right? Those photographs are copyrightable. They're your property. Somebody else isn't allowed to go take them. For software companies, you can copyright source code, you can copyright compiled code. Right? Those are all things that are copyrightable. You can also copyright the splash screen of your app, right? Or your web page. Those are things that you should consider at least putting copyright notices on, right? The first slide I presented to you today had a little copyright notice on the bottom. The slides are not running on. You can't see the slides, Dr. J? Is that your question? I'm sharing my screen. Okay, hold on. Thank you. Well, I'm changing them. I have the share screen on. Give me a second. Okay, you should see slide 2 now. And I lost my chat. You see slide 2? Okay, good. I don't know what was wrong there. All right. Thank you, Jay. You're saving me, or Dr. Jason. All right. Let's move on. I don't know. It was showing up on mine. Okay, where were we? Yeah, what can you get? Copyright, trademark, trade secrets, and patents. So copyright is pretty easy to get. Anything, it covers things like graphics, artwork, software code, written materials, okay, a painting, the layout of a website. All those things are copyrightable materials. Right? Just organized data, like a telephone book, probably not copyrightable. But pretty much anything you create that's visual or even, can be copywritten, or music, right? The audio recording can be copywritten. So the theme song for your startup could be copywritten. I haven't seen a startup have a theme song yet, but I'm sure it's possible, right? So the copyright is automatic. It starts with the person who produces the material, right? And then hopefully, and we'll talk about this a little bit more, there is a transfer of ownership from the producer to your company, right? So they own the copyright. You can establish rights in that copyright just by putting a little label on it saying copyright my startup Inc. and then the year, right? Or copyright in somebody's name, right? So that is what gets you the initial rights. But you can't enforce the copyright until you actually register it with the Library of Congress. Right? So in order to register a copyright, you go to the Library of Congress, and they have a pretty straightforward website. The last time I was there, it was $25, and you could copyright collections as well as individual figures. So you could copyright a collection of web pages as images, right? So go investigate that. In order to actually enforce the copyright, you need to register it. What often happens is somebody will realize that their photographs or their materials being used elsewhere on the web, then they'll do the registration, right? But that's something you can do, right? If you have source code, have a string somewhere in it that says copyright, name of your company, right? Even the compiled code, have a static string that's somewhere in there says the name of your company, right? When you have a splash screen at your when your software starts up, it should say copyright, the name of your company. That's basic copyright stuff. And copyright can be really valuable. I know somebody who is a professional photographer, and she made a business taking pictures of hotels and resorts. Well, it turned out that her pictures were started to be really widely used all over in the tourism industry, right? And so her copyrights were very important to her and worth a lot of money, right? Trademarks. Trademarks are to represent goods or services, right? It could be also the company name, but it doesn't have to be, right? The 7-Eleven convenience store is a great example of a trademark. The same company that owns 7-Eleven owns Taco Bell, which is a different, business and trademark, right? The company is called Southland Corporation. I don't know if even if they have a mark on that, but so the trademark is not necessarily your company, but could be. And it's meant to represent the goods and services. Trademarks can be in a very narrow area. In other words, you can get a trademark on a lady's handbags, and somebody else can have seat covers for Porsche that have the same mark, okay? It can be in a narrow category. It could also be a famous mark, a McDonald's, a Coca-Cola, a Rolex, or something like that. And then that mark gets to be covered everywhere, covers all categories. So when you apply for a trademark, you are asked to go into various, what area is it? Is it providing software services? Is it a barber shop? Is it women's handbags, right? So when you apply for trademarks, you'll pay per classification. How many different classes do you want to have your trademark in, right? And it's the description of exactly what your mark covers is really something that has to be finessed, right? There's a reason to hire a trademark attorney, right? And trademarks should cost $1,500, $2,000, $1,500 to $3,000, right? Depending on how much fight there is. Okay, it could always be more if you have some troubles. But the reason for hiring a trademark attorney to do a trademark is the finesse of exactly the description of your services or product. The wording in that has to be really accurate and precise. If you do too much, you can run into trouble. If it's vague, you run into trouble. That wording is really important. And if you don't have an attorney, the Patent and Trademark Office will just say, oh, you should use this. And they give you some standard phrase. And it might turn out that's not exactly what you really want. Okay, so trademarks aren't something you need to be really urgent with when you start off your company. There's something you can do. You can use your mark, the thing that you intend to be your trademark, and have a little TM symbol next to it, right? The TM is declaring and putting the world on notice that you consider this your trademark, right? And that gives you initial common law rights. Okay, so you can say, oh, I first used this mark in commerce, in interstate commerce, back in December of 2022. Here's a copy of my website showing that the use of that mark, or here's the product I was shipping to Nevada with the packaging that had the name of my product and a little TM next to it. Okay, that gives you initial rights. It doesn't give you yet enforceable rights. To have enforceable rights, you need to have what's called a registered trademark. And that's where the little circle R comes in, okay? So if you register your trademark, then you get to use the little circle R, and that gives you an enforceable mark. When you apply for your trademark with the Patent and Trademark Office, you can tell them, oh, I've been using this trademark for 3 years. Here's the evidence, blah, blah, blah. And that will give you some priority. That will give you some initial rights, okay? So for a cash-strapped startup, when you're first starting off, use the TM, okay? When you have a little money, then go ahead and register 1 or 2 of your most important marks, right? That's going to be the trick. right? So the TM is free. The TM also works all over the world, pretty much, right? In most of the world, it's a first to use situation, right? Whoever's using the mark first gets a leg up. The exception is China, where you have to file, it's first to file, okay? So do a first to use, and once you start getting traction or you raise a little bit of money, go ahead and get in touch with a trademark attorney and get those trademark applications filed in your important markets. Trademarks are country specific. So if I have a US trademark, right, I can use the little circle R in the United States, but unless I have Canadian trademark, I need to use the TM, or I need to say trademark registered US, blah, 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 right? So it's clear, okay? So those are trademarks. Next one, trade secrets, okay? And Kim Shore, I will get to your questions. I'll go through the Q&A once we're all done, okay? Trade secrets. Trade secrets are something that people forget about and can be really valuable as well. So if you, for instance, have a mailing list of intended targets for sales, right? Your target sales list, that's a trade secret, right? You don't want your competitor to know that. If you have a pricing model that you, right? I'm going to price this much under the competition, except under these certain conditions. That's a trade secret, right? If you have a trained neural network, okay, it's a standard off-the-shelf neural network, and you've thrown a bunch of data into it, right, to train it, and there's probably nothing patentable there, right? All you've done is take data and reconfigure a standard neural network to do something. That's probably more likely to be a trade secret. You're not going to give away that network, right? You're not going to look at the coefficients in your neural network and pass them on. That's considered a trade secret, right? How you teach your self-driving car, that's a trade secret, okay? All that data processing and know-how, those are considered trade secrets. The thing that startups really miss out is doing something to make the trade secrets tangible, right? You might have lots of trade secrets, but if you don't pay attention to them, they're going to be relatively worthless. Okay? The trick is to document them, right? Write down a list of what your trade secrets might be, okay? Things that you don't want your competitors to know, right? And then write a half page or a page on each of them, describing what it is. So it might, the first one is trade secrets is how we're secretly filtering LinkedIn and getting new sales prospects, okay? That's a secret. We're not going to tell anybody else about that. The neural network and the algorithm deep inside our code that we're not going to tell anybody about it, or the chemical process by which we heat this plastic and this insect control agent together to release properly over 2 months during a growing season. That's all examples of trade secrets. Document them, write them down, and have a list. These are our trade secrets, okay? And then have a program in place. Who is allowed to see the trade secret? Only people who need to know, not everybody in the company. You don't put it on the server where anybody can log up and download it, right? You have some security protocols. You have a program. All right. If an investor asks you someday, do you have trade secrets? You say yes. And then you can list by name what they are without giving details. And you can say, yes, I have a folder in my safe, which has a description of every one of our trade secrets, or on a secure thumb drive, right? I have a list of trade secrets, and we have a program in place that when somebody gets access to the trade secret, they have to sign a piece of paper that says, yes, I understand this is a trade secret and I will never give it away, right? Until it becomes public some other way, right? So there's a trade secret program in place, and that removes one of the biggest defenses against misappropriation of trade secrets, right? So if you have an employee who leaves and a couple of years later you find that he's gone to work for a competitor and they're all of a sudden using your trade secret, you think they're using your trade secret, you might go after them and say, hey, that was my secret, right? and you're going after the employee. And the defense is, well, that really wasn't a secret because everybody in the company knew it. The sales guys knew it. They talked about it on this, to customers all the time. It really wasn't kept secret. Well, that's what you want to avoid. You want to have tangible, well-defined things that are trade secrets. And then when you talk to your investor, you can say, we have these, we have them protected, and they actually create value. And trade secrets can be huge, right? I've worked with companies where the trade secrets were the golden eggs of the company, right? The things that really made them value. And when they were sold, it was like the secret, right? Here, we're going to hand you the check gets written over in a 3-page document, gets handed back. Here's our trade secret. This is our formula for doing this fantastic process, right? And that was what was worth so much money. Okay. So the last thing we're going to talk about, there are other types of intellectual property. If you're a famous actress, you've got or actor, you have your persona, and you have you're a celebrity. You could have architectural design in property and architectural design, and so on. There's others than the 4 that I've listed here, but the last one we're going to talk about is patents. And so I'm a patent attorney, and as you might guess, that means I'm going to talk more about patents than anything else, right? So patents cover the physical form of something or a process, typically, right? Those are the 2 types of what we call utility patents. There's other types of patents. There's plant patents, there's patents on semiconductor masks, there's other types of patents. But the ones that are most common, and it will most likely apply to you, are utility patents, which can be directed at products, physical systems, a car, a pair of glasses, or a process. For instance, a process of making something, or a process of managing data, or something like that, right? Okay. It's very common. Probably 70% of the patents that I do are for software. So we have a lot of times where we have software code that can be both copyrighted and patented, right? There's a fine line, a fuzzy line between what is and what isn't patentable, right? This is a constant debate, and the law is changing. Every few years it changes a little bit, one way or the other. Okay, there's a pendulum that swings back and forth. A pure business method, like the calculation of risk on an option, right, that's just an algorithm, right? That's not likely to be patentable. Okay. If you do something that results in a tangible technical effect, okay, in Europe, there's a quote unquote technical effect standard, which is actually easier to work to manage than any standard in the US. So that when we write patents, we write about towards the technical effect standard. In other words, something gets changed. It might be data that's reordered. It might be a sorting algorithm. It might be tagging of images. It might be the control of a circuit to turn on anti-lock brakes, right? That's a good example of a case where there's a lot of software and there's also hardware that kind of mix together, right? Every time you use a computer, there's a combination of software and hardware working together. And the question is going to be, quote unquote, what is the technical effect of doing this, right? So the more you are just purely an algorithm or purely the way of doing business, the harder it's going to be to get a patent on something. But once you start having technical impact, either on data or on some physical thing, then the chances of getting a patent get stronger and stronger, right? It's a continuum, and nobody knows exactly where the fine line is between those, right? So when we write patent, if you have a good patent attorney, they're going to be able to present your inventions, your ideas, in a way that really emphasizes the technical effects and gives you an increased chance of getting a patent out of it, okay? So what kind of patents can you get? All right. All right. There's 3 types of patents that are most common for early stage startups. There's a provisional patent application, okay? It's not called a provisional patent. That doesn't exist. It's a type of application, a provisional patent application, okay? and a non-provisional patent application, okay? A non-provisional patent application will turn into a utility patent, okay? That's what we could normally consider a patent, right? It gets published by the patent office, it has a patent number, it has legal rights, and you can assert it against somebody, and it has value, okay? So a provisional application is just a placeholder. It's a temporary thing. As you can see from my slide here, it only lasts 1 year, right? A non-provisional application is much more expensive. It's the one that turns into an actual patent, right? And that's something you can enforce. There's also a design patent. And design patents are on things like hubcaps or the tread on a tire, or I dealt with one recently that was a charger for a phone, how the shape of the charger looked, okay? It's meant to cover ornamental aspects, not functional aspects, right? So in the news in the last few years have been big battles between Apple and Samsung over design patents, right? The look and feel of Apple's interface was covered by design patents, and they've sued Samsung over it, right? One of my favorite design patents, and the one that I used to always give an example of when we all met in person, was the Polycom speakerphone, right? That we used to have at our conference room desks. It's kind of a triangular shaped thing that's like either a triangle or a three-pointed star. That was one of Polycom's most valuable patents, a design patent on that shape, because it turned out that having the speaker in the middle and the microphones around the edge gave you good sound quality, gave you good acoustics. In order to do that, it was a lot nicer to have a triangular shape than like a flying saucer disc. And at one point, the only competitors against Polycom had that flying saucer disc, and it really didn't. It looked a lot bigger and bulkier. It didn't look anywhere near as nice as the Polycom phone, and that was actually one of Polycom's more valuable patents. It was a design application on that phone. Okay, so let's go through each of these in a little more detail. The provisional application is very nice for startups because it is inexpensive, right? It can be done as an informal document. Basically, it's a bunch of papers with a cover sheet on top of it, right? And the value of it depends on how much stuff, how much meat you've got in those papers, right? Examples of a provisional application I would commonly file is just before a scientific paper is about to be published, right? We know the paper is going to come out. We take that paper and we put a cover sheet on it. We file as a provisional, right? Or a company is about to go start doing public pitches at pitch events. We take their pitch deck and we take their, a 5-page description of what they're doing, a technical description, right? Not a marketing description, but a technical description. We put those together, put a cover sheet on it, and file as a provisional application. The provisional application does 2 separate things for you, okay? First, it gives you a filing date, okay? You get credit for whatever's in that document, whatever you give to the patent office on that date, for knowing that material and having those ideas on that date, okay? In the US and most of the world now, we are first to file. So that means that if you've got some secret sauce, some magic sauce that you want to make sure you protect, you need to write it up, put it in a provisional application, and you get credit for that date, right? If somebody comes on by a week later and files on the same idea, you beat them to it, okay? That's a good thing. So it gives you a filing date. The other thing that it does is it lets you file before you make something public. And that's important because in most of the world, once you make something public, you no longer have the rights to file patent applications on it, right? You've got to file first. So for example, if you have an app that's running on a cell phone, okay, and you demo that at a trade show, or you show that at a pitch at some event, right? And you're showing people, and you let a few beta testers go and try it, some potential customers, right? And you get that out in the wild, right? That's all considered public use. It's public use even if the user doesn't get to see what's happening on the back-end server. right? They may not see exactly what's happening, but the impact of the functionality of your code on your server is appearing on the phone. That counts as public use, okay? So that public use would be used against you in any patent you file outside the United States. In the United States, there is a 1-year grace period, but only the US has that. So it's very nice and it's very useful to file first, right? So before you do that public presentation at a pitch event where anybody could be watching, right? Make sure that at least everything in your slide deck and some more support material has been filed in a provisional. And that means you filed first before that public presentation, okay? That will protect you. So again, the provisional application does 2 things. It lets you file before doing something publicly, and it gives you a filing date, okay? So now let's talk about some of the problems with a provisional patent application, right? I just talked about taking a slide deck and a few pages of description and putting a cover sheet on it. You know what? That is kind of the minimum, right? It's not a really in-depth, a typical patent application is 30, 40, 50 pages, right? So there's not so much meat to it, right? The provisional, because it's informal document, often is lacking in lots of details, right? It's usually not strong enough. Your slide deck is not going to be enough to support a full disclosure in a later patent application, right? You need to have more material than that. So the problem with provisional is people will file a provisional, but it won't have enough meat to it. It won't have enough stuff in it, right? So my recommendation is that you work with a patent attorney and make sure that at least you have enough material disclosure in your provisional applications to cover some basic claims, okay? Right. So the provisional application lasts only 1 year. At the end of that year, you have to claim benefit of it in a non-provisional application, right? So you're going to file it within the year, 11 months and 20 days, let's say. You file your non-provisional application, and in the paperwork to that application, you say, I claim benefit of this provisional serial number filed on this date. And that's what gives you credit for that provisional application, right? If you don't do that within a year, the provisional application goes poof, as if never happened. You can't claim benefit anymore. It's kept secret, right? It's stored at the patent office, okay? So that means if you change your mind, you decide you want whatever's in your provisional to be kept secret, you just don't claim benefit of it and it kind of goes away. But you have to file the non-provisional within a year, okay? The non-provisional thing is the patent application that turns into a patent, gives you enforceable rights. It lasts roughly 20 years from the filing date of the non-provisional, okay? That means you have 1 year for the provisional and 20 more years for the non-provisional, giving you a total of 21, yay, right? Okay, it costs a lot more, right? The non-provisional is almost always written by an attorney who's charging a lot more money, right, per hour. And it has to be in a really formal, tight language, okay? Otherwise, it's not very valuable. Okay, let's move on here. One question I get from a lot of companies is, oh, we're so important. We want a patent everywhere. We want a worldwide patent. Well, there isn't such a thing, I'm sorry to say. All right. Each patent is a national entity, right? There's some organizations like the European Patent Office that help you get patents in a bunch of countries at once. But when you finally get a patent from the EPO, you file one application there. And that application is examined all at one time, right? And if you get an allowance, then you say, okay, I want Belgium, France, Switzerland, and Germany, or whatever other countries you choose. You have to choose which countries you want to go into. And then you get a patent in those countries. So one European patent application might be 2 or a dozen different patents in individual countries, right? Okay, so that means that your US patent is not going to be enforceable in Canada, right? Your Chinese patent is not going to be enforceable in the US. filing patents around the world is really expensive. Okay, the only people who do that are pharmaceutical companies, right? Where the drugs are so valuable, right? That they'll bother patenting in Malaysia and in India and in China and in Japan, etc. If you're a early stage startup, you are probably going to file in the US, right? You might file in one or two other countries. And where you file will depend on a couple of things. Where's your big markets, right? If you are a dating app that's big in the West, you might file in the US and Europe, okay? If you are a product for cars, right? You might file in Japan, right? Because of Toyota and Nissan, and in the US and in Europe, okay? So you will look where your big markets are. You will look where your competitors are, right? If you have a competitor in Ireland, your number one competitor is Ireland, well, there's a reason to get an Irish patent, right? Because you want to have patents where your competitors are based, where they have a big presence. And finally, you want to patent where your acquirers are. If you think Samsung is going to buy you, then you're probably going to want to file in South Korea. Okay, that will make your company more valuable to an acquirer. Okay, so those are the reasons, and you can sit down with your patent attorney and decide the budgets and the costs of this. You know, a patent in Korea is over its lifetime is going to probably cost $50,000, right? I mean, because you have to pay annual fees every year on it, right? And then enforcing it there is expensive as well. Okay, so those are the decisions. You won't do worldwide, but you're going to do all the major markets, and you're going to sit down and have a good budget discussion with your patent attorney about really what makes sense. All right. Sometimes the choice is, okay, we have 10 ideas. Do we file a patent on one of them and then try to do patents all over the world? Or do we do 5 patents, a kind of a mixture of country here, country there, kind of make a minefield for the competition, right? So there's all kinds of strategy behind that. Cool. All right, let's move on here. When to start thinking. All right, this is the Beatles song, Yesterday. So I often see early stage startups before they talk to investors, right? I'm the first attorney they walk out to, right? It might be a group of founders before they haven't even started a company yet, okay? And their question is, okay, we have IP. We think it's going to be important part of our company. What do we do about it? And so really, you know, I gave examples already to you that where you pitch, right? When you start pitching, it's nice to be in stealth mode for a little while, get some good technology, do some development, have stuff worked out, right? And then when you want to start raising money, you file some provisionals, and then you start screaming to the world how great you are, right? Okay, so do initial provisional filings early. And the reason I'm saying provisional is because they're so much less expensive, right? You want to keep on a budget. You want to file some provisionals, and then you have a year to raise real money, okay, and be able to afford filing of non-provisional applications, right? And if you haven't raised money within a year, then do something different, right? It's a year, you know, you're trying to get people to invest $500,000, $1 million in you, but you've spent a whole year of your life, which is actually pretty valuable, okay? If you file some provisionals and haven't gotten traction within a year, then come up with a different idea. I'm sure you have other ideas, okay? So sorry. So that's it. So start early with the IP process, okay? Either discussing things among, you know, keeping notes, right? You all should have notebooks that you carry around, like physical bound notebooks, like in lab courses in college, right? A lab, you know, your chemistry lab, you had to have some notebook, right? You were if you were in my class, okay? Write down all your ideas there. Every time you go to a meeting with anybody, pull out your notebook and take notes, okay? That's a sign of a good founder, right? A good CEO. They always have a notebook with them, and they know what they talked about 6 months ago with the same guy, right? So write down your ideas, start working on IP. When you found a company, right? If it's not just you, that means you have different people coming in with different ideas, okay? Who owns the ideas? Is it going to be the company, right? When I talk to two people, at a Starbucks for their first meeting, one of my questions is, okay, do you guys have an agreement between the two of you, or gals, right? Do you have an agreement between the two of you as to, yes, we agree to assign all of our IP to the company. It's going to be a shared asset, right? Okay. So these are the types of things that you wanted to do. These are the types of things you want to have. Get those early steps in place, and that's where those are kind of the initial discussions you want to have with an attorney. You want to talk about agreements between founders and IP. Those are the first two things that you have to have before you even start, create the company, right? Preferably. Okay, moving on. Now you know when. It's a good thing you're listening to this presentation, okay? All right, I'm going to talk about now something that most patent attorneys won't mention, budgets, okay? There's a really good incentive for me to talk to you about budgets. I want to get paid, okay? So that means don't blow the budget. Make sure that founders have good expectations of how much things are going to cost, right? We've talked about how much things are going to cost. There is a cap on the expenses, right? We know this first provisional, it's going to cost so much money, right? Now, I'm going to show you real numbers. Keep in mind that I am California attorney, right? I work out of Ramon Law's offices in Lake Tahoe, which is nice. And I'm also associated with Menlo Park office. I live in Reno. And most of my clients are Silicon Valley early stage type companies, right? They might come from Australia, but they're still trying to get into the VC ecosystem and are looking for angel investments and so on. So this is the type of company that I deal with, right? So these are the numbers. This is kind of typical. And I've looked over lots of patents I've written in the last 20 some years. And this is kind of the current going rate, all right, for me. All right, what does it cost? Okay, we talked a little bit about provisional patent applications, okay? So I will do a provisional application for $2,500, all right? You can do it cheaper. There is a book on Amazon called Patent Pending in 24 Hours by Nello Press, and it's about 40 bucks, I think. You can buy that book and read it and do your own thing, okay? My advice is to at least work with a patent attorney, right? To make sure that you've got the right stuff in there, okay? There's more to writing patents than just filling in a form, right? There's really digging down and understanding what's special about your technology, what you've invented. I spent most of the 90s, the 1990s, for those of you who are young, as a CTO of a chemical instrument company, right? I did trade shows, I designed products, I spent an awful lot of time in AutoCAD and having metal cut and doing electronics and firmware and things like that, right? So I was building products. And my background is really, a product manager at heart. So the thing you want to cover in your patent applications are the things that make your products really special, right? I don't want to write patents. I don't want to see patents that the engineer thinks are really cool. I want patents that the sales and marketing guys think are really cool, because they cover those things that make your customers excited and your investors excited, right? The feature of your product that the sales guy says, we have this, you got to buy us. You can't do without it, and there's no replacement. That's the thing that you want to cover in your patent. So working with a patent attorney to make sure those magic bullets, those silver bullets, or whatever you want to call them, are covered, that's what you want to engage with a patent attorney. So $2,500, we will meet for an hour and a half, discuss the technology and inventions. I will come back to you and give you a set of claims, which is an important part of a patent application, a summary, and maybe some block drawings, some simple diagrams, and an outline. And I'll hand it to you and say, fill in this outline. And the goal of doing it that way is so that I know that written into this provisional, we at least have enough material to support those basic claims, right? Okay, so that's one way of making sure that there's at least enough in the provisional application to support a later non-provisional application. Okay, so the non-provisional filing, I have here 18,000. That varies by thousands of dollars either way, right? The reason it's so much more expensive is it's generally written by the patent attorney. Okay, we start almost from scratch. Sometimes rewrite. I have a few clients who've been doing this, who've been clients of mine for decades, right? Who are pretty good at doing this themselves, and their cost is way lower, right? Because they can do it, right? It takes about 10 to 20 years to learn to write good patents. So this is a very rough ballpark figure. You know, there's filing fees at the U.S. Patent Office. You notice here there's two lines. There's a red line and a pink line. It turns out that patents can be members of families, right? So I could write one description, one specification for a patent application, file it, and then 3 months later say, oh, we've got these 5 new ideas, big improvements on what we did before. So what we can do is we take that original specification, we add another 10 or 15 pages to it, okay? And that makes it longer, but the new pages have the new stuff in it. And we file that as a kind of daughter application called a continuation in part. And it's related to the parent, the original filing. Right? And so families of patents can have dozens, you know, of patents in them, patents and patent applications. And when you file the daughters and the granddaughters and the great-granddaughters, the cost is much less because you've already written a lot of the material. So the cost drops down. Now, I've looked at some of my clients who have pretty good sized portfolios, and the cost drops to like 9,000 to 12,000 a piece for the filing, including the filing fee and everything, right? So that's the costs in your first year, right? So hopefully, between the time that you filed your provisional application and the time it's time to start the non-provisional, like 11 months later, you've raised money, okay? $500,000, $1 million, right? And in that, you've budgeted in your first year for a couple of non-provisional patent, maybe $35,000, $50,000, depending on how aggressive you are, right? Of all the money you raise, you're gonna direct towards IP. And you're doing it, remember why? So that you increase the valuation of your company, so that when you do your post-seed, pre-A round, whatever it is, you get a better valuation, right? And then finally on exit, you get a great valuation, right? And I've seen cases where there's a couple of companies that are doing almost exactly the same thing, and there's an acquirer, and the acquirer looks at them and says, well, which one should I buy? Right? And the IP, I've seen the IP portfolio make a big substantial difference in that decision. One company has a beautiful exit and the other one dies, right? So it can be really important. At 18,000, you now have a patent application that is on file. You are, right? You don't yet have a patent, okay? Normally what happens is 1 to 3 years later, the patent office gets back to you and gives you a rejection, okay? 95% of the first action from the patent office is a rejection of the claims. And then your patent attorney has to respond to this, what's called an office action. They can respond by amending your claims, changing what you think is, what your claim is your part of the invention, right? If there's some prior art that's a problem, right? Or arguing back, explaining to the patent examiner, no, you're wrong, this isn't quite right, this is really what's happening here. This can, on average, happens something like 1.9 times, right, on it for a typical patent before either the patent becomes abandoned or it turns into, the application becomes abandoned or it turns into a patent. So you can expect those responses cost about $5,000 a piece, roughly. You can expect to spend, then you get an allowance, and then you pay some issue fees, almost, you know, $800, depending on, well, depending on the size of your company, you pay issue fees. You can expect that over 4 to 5 years, that original patent provisional application, you've now spent $30,000 to get your first patent out. Okay, that is a good ballpark figure, right? So keep in mind, that's the kind of things that the patent portfolio should do. But hopefully it's making millions of dollars in difference in your valuation, right? Okay, that's patent costs. Let's move on here. Oh, I can talk about some of the issues. Okay. This is important, okay? Ownership of IP is a something I have seen kill companies, right? You bring on a team, you bring in people, you're trying to put all these fires out, you have no money, you can't afford attorneys as much as you'd like, as much as you really need, okay? And your company grows on and you're now 3 or 4 years in and you realize that some engineer didn't sign the right document and your company is dead, okay? Ownership, whether it's copyright or patent application or inventions, initially vests in the inventors, right? That's in the US, okay? In some countries in the world, and I'm not a Spanish patent attorney, but maybe perhaps in Spain, there's more of a presumption that if you're employed by a company, your inventions become property of that company. But in the US, it's pretty strict. The property of the inventors, the inventions start off being owned by the inventors. All right. And you need to transfer that ownership from the inventors to the company. Okay. And the inventors could be the founders, right? They could be the founder's brother-in-law. They could be employees. They could be consultants. They could be salespeople. You'd be surprised who comes up with good ideas. One of my favorites, okay, we're going to do a little aside here, is Adobe Forms, right? We have all used Adobe Forms now. It's really useful. It helps, you know, my kid's school sends me a Adobe form to fill out, okay? That was invented by a sales guy at Adobe. He said, you know, we have this document. It'd be great if you could fill in little blanks, okay? So it's important that everybody involved in the company, right? Everybody you can get to, right? A consultant may be a little bit more iffy. A contractor, right? A development contractor, right? Who's writing code for you and writing code for lots of other people may have some discussions about your IP clause, right? But you want to make sure you have ownership of all the inventions that relate to your product, okay? If you're in the United States, it also depends a lot on which state you're in, right? If you're in California, right? California is much more friendly to inventors and less friendly to companies than Florida is, for example, right? So in Florida, a company can have a inventorship clause that owns a lot, right? In California, if you're a software company and you're working on semiconductor, ways of designing semiconductors, and your employee comes up with a brand new lawnmower invention, your company's probably not going to own it, right? Because that's so unrelated to your business. But in other states, this is a state law issue, right? In other states, there could be a clause that says any invention the guy comes up with, or gal, is owned by the company. So you got to be careful, right? It's state dependent. You need to have an agreement between again, I'm going to say this again, between the founders and every employee, every contract that you can have. You want to think about who's going to own the IP. If you are doing joint development with another company or with a university, right? You want to make really clear who is going to own that IP, right? The other thing about ownership is you want to make sure that people don't bring in other IP into your company, okay? So if you hire an engineer from a competitor, you need to have them sign a document saying, I agree, I am not going to bring any trade secrets from this other company. The engineer who says, you know, I wrote this last time. I wrote this 2 years ago for somebody else. I'm just going to take this whole block of code and drop it in and take the week off, right? Because I have already done this. All of a sudden you have a huge issue, right? It could be a trade secret there, definitely copyright issues. It can be really important. You need to make sure that you actually take affirmative steps to remind employees, don't bring anything in, right? Because it's not worth it. It will hurt you, okay? If you're a founder and you recently worked for a company in the same field, you need to sit down with your patent attorney and have a detailed discussion on the facts of your particular situation, right? I can't say anything general about this, but if you're leaving Google and you worked on a project in AI generated art, and you're going to start a company doing AI generated art, you need to make sure that you sit down with your attorney so that you don't get really successful and then get sued, right? You don't want to do that. And your investors will be really unhappy, right? They'll come after you. So you got to pay attention to these things, especially the closer you are to your last employer or some previous employer, okay? I want to talk a little bit about open source. You can use open source material in your product, but you need to make sure that your attorney has read the license agreement for it, okay? Some open source material requires that you also make your product open source, right? So great, you've got this open source printer driver somewhere in your huge piece of fantastic software. Well, boom, all of a sudden, you're legally contracted to make your entire source code base public. Okay, not good. Right? This actually happened to a former president of ours a while ago. He tried to develop his own social network system, and they used open source software, and all of a sudden realized that they had to pull the product from the market and rebuild everything from scratch. Okay, so somebody who was getting bad legal advice. No more comment there. Okay, make sure that you follow the assignment process, right? So when you file a patent application, your patent attorney is going to give you an assignment document that's going to assign that property, that application from the inventors to the company, right? And they're going to record that. Just like when you buy and sell a house in most countries in the world, there's some government agency where you record the sale, right? So when you transfer ownership of an invention, ownership of a patent application or a patent, there's a recording process at the USPTO, and you have to follow that recording process, okay? There's specific steps, and so it's a public record of actually who owns the patent application, the patent, okay? So make sure you follow those recording. So initial, one of the first things you're going to do after you found the company is assign the IP from the founders to the company, right? Let's go on. No. Let's talk a little bit more. I touched on this a little bit, all right? Patent as from the point of view of your marketing and sales guys, right? As a former product manager, you want a product that sells, and the reason people buy, those reasons, that's what you want your monopoly, your patent monopoly on, okay? So look at the things when you're deciding what to patent. It's both a top-down and a bottom-up approach. The bottom-up approach is engineering comes to you and says, look, we figured out this cool way of doing X, right? We've come up with X and Y and Z, and these are the coolest things in the world, and I think the engineering is awesome, right? And then you look at what's really going to make your company successful, right? And this might be the points you're making in your early pitch decks, right? You're going to tell investors, we are going to be the next unicorn because A, B, and X, right? Okay, these are the things that are going to turn us around and make us conquer the world. These reasons, right? And the reasons could be technology, it could be the team, or it could be something else, right? Okay, let's assume at least one, let's say X, is the reason, right, that you think, the technical reason why you think you have a big advantage and why you're going to be such a successful company, okay? So that means that your sales and marketing people are going to be going to customers and saying, we have X, okay? You've got to buy us because of X, or the salespeople come back and say, you know what our customers really want? They like X, okay? X is great, all right? So X is what you want to focus your patents on, okay? Right? The product engineers said it was cool. The marketing people say it's cool. That should take that feature, that the technology that enables that feature, and pull it to the top of your patent list, okay? So it's important to have that strategy, all right? I talked about Polycom and their speakerphone earlier. And Polycom wrote, I know one of my first bosses was the patent attorney who did work for me when they first started. There's two guys, two engineers, right? And they wrote a lot of patents on noise filters, and they're all electrical engineers. Right? They didn't write a patent on having the speaker in the middle pointed up and the microphones distributed in a circular pattern around the outside, okay? That would have been nice. That's what made the big sound, right? Having the sound go up to the ceiling, and then the microphones being able to receive the sound from people sitting around the table. So this is a good example of, oh, it wasn't the clever electronics, it was like the layout of the speakerphone, right? Okay. This is, sometimes things that you think may be simple can actually be the thing that really sells the product. And if it's simple, it doesn't mean it was obvious, right? So a simple invention is still patentable if it wasn't done before and if it wasn't obvious, right? So those are the things you want to get, okay? Your strategy needs to be product driven, right? You supposedly, right, will have a product roadmap. Here's our minimal viable product. Here's the product we expect to have in 18 months, and here's the product we expect in 2 years, 3 years. Right? This is our product path. These are the things we're going to introduce. This is why we think customers are going to love it, and those are the things we're focusing our patent applications on, right? Okay. Keep in mind, it's for the valuation of the company. When you are doing your A round, right, and you're doing a 10 or $30 million raise, okay, at a valuation of 100 million bucks, right? I want you, and I will make slides for my clients like this. I do a cluster map. I want you to be able to describe to your investor the few things, the magic bullets, right, that are making your company a winner. The feedback from your customers, they say, this is why you're so successful. This is why we're getting so much engagement, why our sales are up the roof. This is it. These are the features, okay? And then I want you to show a slide with those 3 or 4 features as bubbles in the middle. And around them, bubbles of a dozen different patents and patent applications with lines drawn between them. It's a big spider web. It's called a cluster map, right? Showing the relationship between the things that are making your company really special and your patent portfolio, okay? The purpose of this is to make the IP more than just a checkbox. You want to convey the value. I'm talking now a couple of years, guys, right? Or gals, folks, when you want to be thinking about IP now to make your company, to be able to do this presentation in a couple of years and get a check for $30 million, right? And then 2 years later, exit and retire. That's it, okay? Make the IP more than checkbox. And you've got to start thinking about that now, right? That's part of the goal, okay? Now, moving on, I talked a little bit about this, okay? Other people's IP, okay? And it's already 10:05. I've got, what slide am I on? I'm almost done. Okay. 2 more slides. Read the literature, okay? If you are working for Intel or a big company, Amazon, the company may discourage you from reading patent applications, because if you are aware of something, the company, that makes the company aware, and that increases their liability, right? You're a startup, okay? It's to your advantage to know what else is out there. You should be doing research on your competitors, other people in your market. If you don't think there's anybody right in your market, look at what are the closest ones, okay? Read the literature, okay? I have a science background. I was taught to go into the library and spend an afternoon every week in the library reading about what other people are doing, okay? So benefits you to see what your competitors are doing, what your competitors might be filing patent applications on, right? Because when you're Intel and you see a patent that's a problem for you, you're kind of stuck. You can't really re-engineer your chip, okay? But when you're a startup and you see a patent that's issued from a competitor that's kind of close to you, you can probably engineer around it. You can work your way around it, okay? And save yourself years of work, okay? Save your investors lots of money. If you know about it ahead of time, you can kind of tweak what you have to avoid it, right? So read the literature. And finally, reading the literature will give you more ideas. You'll read what else somebody else is doing, going, ha, yeah, if they only knew about our ideas, they would get to here. Boom, now you have another basis for another patent application that's going to block that competitor, right? Their technology plus your technology is a great new invention, right? Okay, you can do that. So as an early stage startup, I encourage you to go out and read. And this means, going to Google Patents and doing searches on your own. And if something comes up that seems to be of concern, report it, show it to your patent attorney. Keep a record of what you see, right? Because at some point you do need to report, if you know stuff that's related to your technology, you need to report that to the patent office, but do these searches, right? Keep records, right? And this means when you're in a meeting and you're having a discussion about new technology, write down, Susie had this idea and Karen improved on it with this, boom, boom, we have a new product line, okay? So Susan and Karen are probably inventors, right? They conceived of these ideas, right? Having your notebook, right? You're going to carry a notebook around. Having records of those meetings in your notebooks can protect you in all kinds of ways. It can help figure out who said what, when, right? Whose idea was it? Let's give an example. You have you're an electric bike company, and you want to you have a bunch of new ideas and you're having this meeting with your engineers and you're writing it down in your notebook or in your electronic notes where it's saved in a secure place, Yahoo email account, right? It's saved somewhere on the web, right? You have a secure document of it. You have now these notes, and then a month later you hire somebody from a competitor, right? And 3 months later the competitor sues you for trade secrets. For misappropriation of trade secrets. So these ideas all came from our employee. Well, fortunately, you have records, right? You have notes you kept. No, we already had those. We had those ideas 2 months before we hired this guy, and we filed a provisional patent application covering them 4 weeks later, and you've just saved yourself a $250,000 lawsuit and maybe the end of your company, right? So keep notes, keep records. I can't say that more. All right. One more slide here. Keep in mind, find the button. There we go. Avoid these mistakes. Ownership. Make sure you own your own IP. Get assignments, okay? Whether it's copyrights or patents or whatever. This means that if you hire somebody on Fiverr or Upwork, right, to design a company logo for you, when you do that hiring, there's actually a checkbox, right, that attaches an IP clause to that agreement. If you don't check that checkbox, the person who designed your company logo, he or she still owns it. Sorry, they might decide to sell it to some Chinese company or somebody in Australia, and boom, that logo is being used somewhere else, and you don't necessarily have the rights to it. Make sure you own your own IP, okay? Right? The second ownership mistake, remember? Other people's IP. Make sure other people's IP doesn't find its way into your product, okay? Third mistake, this is the review, right? Don't wait. Do IP early, okay? When you found a company, you need to have some money, right? Otherwise, the investors will see that, right? If you're deciding to pay rent or hire a corporate attorney to look at an agreement, the investor will know that and they will just hold you over the barrel, okay? You need to have some money in the bank. I mean, friends and family money, whatever, your job at Starbucks, okay? But get IP done as early as possible, okay? Have a strategy, okay? You're gonna write down with your founders, your team, you're going to say, okay, here's our company plan. We expect to have these features, that you have a product roadmap for at least a couple of years, right? You should have the same thing in IP, okay? Have a strategy and figure out which things are important. If you spend lots of money trying to get patents on the wrong stuff, it doesn't give you the value you might have got, okay? The last thing, and I don't have time to talk about it, and I do another talk where I talk about the anatomy of a patent, okay? It's important that you understand that document, right? There's some figures, right? There's a data page in the beginning. There's something called a specification, which is lots of columns of words. And there is something called claims, the end. Each of those have an important meaning to them, okay? Because we're kind of low on time, I'm not gonna be able to go into that, but make sure that when you are working with a patent attorney, ask him or her, please explain to me what the difference between the claims and the specification are, right? Ask that question, okay? Your patent attorney should be telling you these things anyway, right? But make sure you ask that question so you understand what a big claim's like, right? I'm going to tell another story here, okay? I know I'm over, but I sometimes have people come to me and say, I just got this fantastic patent. I want to sue everybody. It's worth $1 billion. You should work for me for free because I'll give you a little piece of it. It's so fantastic. And then he hands me this patent. And the first claim is a 1.5 columns long. So to infringe a claim, somebody has to do every element of that claim. If a claim, there's a hand rule. If you can put your hand over the claim on a patent, all right, and it sticks out, it's probably pretty hard to infringe because you got to actually work at doing every single thing under that thing. All they have to do to avoid infringing in your patent claim is to not do one limitation in that claim, right? The longer the claim, the narrower it is. The shorter the claim, a claim with just a few lines, is probably really broad, okay? So in your patent application, you want to have claims of different scope, some broad and some narrow, but you need to understand that, right? I see people getting patents and, you know, they got a cheap patent attorney who just charged them some flat fee, and there was no trouble getting this patent because the examiner looked at it and said, oh my God, yeah, you know, nobody's ever going to do all this, right? So it's easier to get a really narrow claim, but it's really relatively loose. So come back sometime and listen to my presentation on the anatomy of a patent, and I will just spend a whole hour plus talking about how to read that document. Okay, so that is it. This is my contact information. I am now going to go through the Q&A. We have 16 minutes left. I'm going to go through the Q&A. And then I am going to kind of quickly go through the chat. If you have specific questions for me, please email me. There is my email address. Right? And you can connect me. Feel free to connect with me on LinkedIn. I don't read my LinkedIn messages quite as often as I do my email. There's quite a bit of them. But that's the best way to connect with me. Okay, let's see. We have... the first question is, Dr. Colby, where and when in the process of starting business should I come to you for your services? Early, right? You won't get charged. Okay, the first half an hour is, anybody here, I will give you half an hour of advice on your specific needs, right? Yeah, come and talk to me, or email me. We'll set up half an hour call, and I'll talk about budgeting and where you are in your process and your needs and different things like that. I'll give you an idea of what to expect. Okay, again, the best clients are clients that really understand the relationship between the attorney and what the attorney is going to do for them, and not. So come early and just have that initial talk, right? Just like you're coming to this presentation, it's really helpful to have a discussion. And sometimes the talks end up to be like, well, sometimes it's like, I'll say, I have a client just like that. I'm going to refer you to somebody else because I don't work on the same subject matter from 2 different clients. But I'll be able to give you ideas of, budgets, costs, timing, pitch decks. I do review pitch decks. I do introductions to angel investors, stuff like that. So yeah, connect early, and then it might be that you say, okay, I'm going to go work on this for 6 months, and you come back to me again in 6 to 12 months. So, okay, next question. Software code. Yes, software and various logic can be both copyrighted and patented. Pure algorithms, not so much. You're going to have less luck there, right? But definitely software code that does something, right? Makes a physical change to data in memory, or has some technical consequence. That's more likely to be patentable. Okay. Next question is from Don. I have a patent expiring in 7 years and wonder the impact of a daughter patent has on prior patent. So Don's asking, he says he has an existing patent and is asking about daughter patents. You can only file daughters while your application is still pending, right? The day that your patent issues is the last day you have to file any daughters. If you wait till the next day, it's cut off, okay? So if you have a patent that's now 7 years old, I'm assuming you don't have any existing daughters applications pending, right? You can't continue to build on that family. So it's really helpful to always keep if you have an important set of patents, always keep at least one application pending, right? That goes all the way back to the beginning, so that if you find out you want to tweak a claim, all of a sudden a competitor comes up with a product and it's like, oh, that doesn't quite fit our issued claims, but we can now file. So I have patent applications now that I'm filing that are 16 years past, that will only have 4 years of life to them, because it's been 20 years since the earliest priority dates. Okay, the daughter application expires as a patent 20 years from the earliest claimed non-provisional filing date. Right, so you can't do this forever. Okay. So Anonymous is asking, Google Patents is a good source. Yes, Google Patents is a good place for searching. Do I see there all the claims which have been made in the filing? Yes. So there's two things you're going to find. You're going to find issued patents and publications. So a patent application can be published or not. Right? Doesn't necessarily. There's different conditions under which it would not be. And mostly it's the choice of the applicant. So when you read something, first thing you look in the upper right-hand corner, does it say patent or does it say pub num, P-U-B period, publication number, right? And if it's publication, that means it's a pending application that actually hasn't been issued as a patent yet. So it could be that the claims, the coverage of what's there could be changed quite a bit in the back and forth with the examiner. So that's not an issued patent. Sometimes people come to me and say, oh my God, look what somebody patented it. So that's a publication. There's no way they're going to get that. Okay. So, but yes, Google Patents is good. And in a patent, the issued claims are listed there. I mean, you can see you click on the PDF, you see the whole document, right? And with a publication, the pending claims at the time of publication are included there. All right, we have 11 minutes left. Moving down, Casey, what do you suggest for someone who filled their own provisional patent, but they're worried they may not have done it well? Yeah, question is, can you update it? Do we have till the end of the 12 months period? So, Casey, what you can do is you can file again. You can take your existing document and add 5-10 pages to it, or add content material to it, and file it again as a second provisional. Right, and I have seen over 200 provisionals referenced in one non-provisional. Okay, it was by Walmart. I don't know why they did this, but so you can file a whole series of provisionals over the year, right? Especially one advantage of provisional is you put $2,500, or you put some time and effort into it, or money, and then if you change your mind, you go off in a different direction, you haven't spent tens of thousands, right? So if you're still developing your technology, file a provisional, because in 5 months, you may have a lot more to. So I'm going to file today a drone application where the first provisional was filed about 3 months ago, and today I'm going to file another one, which is the same document, but adding and doubling the size, right? I've added at least 10 more pages to it. And those are all the improvements that were made over the last few months. When the non-provisional comes around, it references all the different provisionals, and you get credit for the filing date of a material when it was first filed. So stuff that showed up in the second provisional application, it gets a filing date of that provisional. It doesn't get the earlier date. That new subject matter gets the later filing date. Credit for that later filing date. So yeah, if you filed something a while ago, it wouldn't be unusual to file several times before the 12-month period is up, okay? And kind of after 10 months, you should be talking with a patent attorney about filing a full non-provisional patent application. Okay, Lena. Lena's asking, should a patent search be done before a provisional or non-provisional application? So you can do it yourself. Do Google Patents, search by the competitors, find out who their inventors are, see what else they're doing, search by keywords. Start that way, right? And that's kind of reading the literature, as I talked about. You can hire people to do a patent search for you. To do that, you need to give them a description, maybe some claims and a summary. So you've probably spent 2 or 3 hours of attorney time. And then you'll get a search back with something, okay? You can be charged for a search. They can be $600, but they can be 6,000 easily. They can be 10, right? Depending on, so before starting a multi-million-dollar patent litigation, somebody might spend 6 to 12 grand on a really thorough worldwide professional search, okay? If you're just doing a provisional and you're starting a company, you would farm out to India or South Africa or someplace a search at a much lower cost. And of course, the quality of the search is somewhat proportional to the amount you're paying, right? A really expensive one will have a professional team, expert in your area, doing search everywhere, right? The problem is that if somebody filed a patent application last month, it's still secret, right? It may not be public until it issues as a patent in a few years. So but it's still prior art against you. It still can be held against you. So there's stuff out there that even the best search in the world won't find, okay? Then, so after you get the search report back, your patent attorney has to look at it again, right? Which means another couple of hours. So you've spent 5 hours of attorney, right? 4 to 5 hours of attorney time, a couple $1,000, right? Plus the search fee. And the provisional filing fee for a small entity is only 75. I mean, so that's more than doing the whole provisional. So from a business point of view, do your own searching and then spend, in the low thousands on your provisional patent application, right? It might be that before spending 18,000 on a non-provisional, okay, now it's a good time to do a search, because if we get results in the search that really nails it, then we're not going to spend that 18,000. Okay, that's the time where you might consider doing the search. And I have maybe 2 out of 60 clients that do that on a regular basis. So it's not something that's very common. My suggestion is read the literature yourself. If you're in the field, you should know everything everybody else is doing, all the other people in your field are doing. Okay, that's Lena's question. Now jumping over to the chat, we have 5 minutes left. Thanks, Dr. J, for fixing my slides. It was helpful. I will be doing another talk next month. You mentioned a physical notebook. Oh, hey, Patrick's asking, you mentioned for taking notes, you mentioned a physical notebook to note everything. Is a digital notebook, iPad okay as well? So you want to have something that's demonstratable. A physical notebook's good, and I know people who do that. I use a Proton Mail email account, right? It's a very secure email, okay? And I have an email address, and the only thing I do with that is send emails to it myself. to store records, right? And I have used that account in the past to demonstrate that I had possession of stuff or documents, right? And gone actually in discovery, in a litigation, said, no, here's an email from this date having this material in it, okay? And it could have been Yahoo or Gmail, right? Because once you send a mail to your Yahoo account, it's there as a record that you can't change it. You can't go and fiddle with the email, right? You want to have something that's demonstrable, right, as being there. So I have an account where, when I finish my taxes, or if I do a lease on some property or something like that, I take the PDF. It's kind of my filing cabinet. Like I used to have a big 4-drawer filing cabinet in my office, and I don't have that anymore. I now have this place that I send notes. And every time I'm at a meeting, right, with clients now, it's usually over Zoom, it's a camera like this, I have a window open and I write down, I'm constantly typing, taking notes during the meeting. And when that meeting is over, I copy that email, I copy what I've written, I save the Word document into the client directory, right? And then I take a copy of that and I drop it in an email and I send it to my archive address. And so that's how I keep those records. And so it can be electronic. It can be really useful. Just got to find a way to update it. And using a third-party email service is one way of doing that. Okay. Thank you. Swiss Tech Acts are respective claims of things that are licensable. Well, the whole patent is licensable, but you can cut that license into pieces that are covered by different claims, right? So you could cover, if you own a series of patents, you could give somebody the rights to sell in California or in Canada. You could give somebody the rights to license a certain version of the product and somebody else a different version. You could give an exclusive license, a non-exclusive license. But the claims are the enforceable part of the patent application that the inventor thinks is they are first to invent and was non-obvious. Okay, those are the two requirements for patenting something. Two of the requirements. It has to be patentable subject matter. No pure algorithms or no, natural laws of physics, right? It has to be something that hasn't been done before, and it has to be not obvious. Okay. Questions? Is a digital notebook writing notes on iPad? Okay, we mentioned. Yeah. Okay. That's it, folks. A link to the recording will be sent out. Light on my face. Okay. A link to the recording will be sent out within the next week. Thank you all for attending. And again, in the next few months, I'll do that talk on anatomy of a patent. So thanks very much and happy Monday. Have a good week.